Hello everyone, in the lecture 29.4. Okay, now we have discussed till certiorari, prohibition, mandamus, habeas corpus and all. Now we are going to discuss about what exactly this writ related to quo warranto. Quo warranto. Okay, what is that? Quo warranto, it is issued only to the public office. It is issued only to public office. Okay, now it is issued for why it is issued? To ensure that such a person is qualified to hold that office, to public office, to ensure that such a person is qualified to hold that public office, okay. Let us suppose, I will give you one example. In Jharkhand, engineer was an appointed for a to a local authority for a government office, okay, for which he was not suitable. Okay, matter went to the court. Supreme Court issue will quo warranto. Supreme Court will issue quo warranto, and that person was removed from that post. Okay, so this quo warranto will not applicable to the minister. Removal of minister is only through the power given to the governor. That if you want to remove the minister, you can't do with the quo warranto. But yes, any public officers kind of things, yes, you can do so. As I give an example, that let us suppose the engineer is there, he is not suitable for his job. In that case, quo warranto can be issued by the court. Okay, and in this principle also, locus standi will not be applied. So what we have seen till now, locus standi is not applied to quo warranto, and locus standi is not applied to habeas corpus. What is locus standi? That person himself has to be the person who has who is involved with the writ petition. That person himself has to go and file a case. No, okay. So that is meaning of the locus standi. So in the case of habeas corpus, person himself is in that is detained, can't do so. In quo warranto, it is anyone who feels that the person is not qualified for that post. Anyone can file a writ petition to the High Court, that quo warranto writ petition, that that person is not well qualified for this position, please remove it. Yes, Supreme Court can issue that, and yes, in that locus standi will not be applied. Anyone can do so. Locus standi is applied to mandamus, prohibition and certiorari. Okay, now we'll see this quo warranto will not be applied to the minister. Minister can only be removed by the governor. Okay, so we'll see what exactly till article 32 we had this our fundamental right from article from 12 to 35 we have seen that all the aspects of the fundamental right. Okay, so now we have covered that writ petition also, whatever the writ petition we have discussed, habeas corpus, mandamus, prohibition, certiorari. Quo warranto is there. We'll just revise what is exactly present in the quo warranto. Quo warranto is a proceeding where the court inquires into the legality of the claim which a party assert to a public office and to oust him from its enjoyment if the claim is not well founded. The condition necessary for the issue of writ of quo warranto is that the office must be a public. As I have said, the office must be a public, and the office must be a public, and it must be created by a statute of by the constitution itself. Okay, that is fine. Now the office must be a substantive one and not merely the function or employment of a servant at the will and during the pleasure of another. It should not be that a person is working on the pleasure on someone's place. Okay, that person to whom we have going to file the case, the person himself will be should be the appointed for that case only. It is not like that that person is working on behalf of someone else. No, that not be the case. That is the case of some illegal some other case, but related to quo warranto, that is not applied. The person who is appointed for that post, that person will only be liable for that. Okay, and there has been a contravention of the constitution or a statute of a statutory instrument in appointing such person to that office. the limitation on the enforcement of the fundamental right will discuss currently. Okay, so this was all about the quo warranto things. Okay, now Parliament has the power to modify the application of the fundamental right. This is not related. Whatever the writ was there, we have covered it. Okay, I'm just telling, just ending the all the fundamental related stuffs and all right now. Okay, so now Parliament has the power to modify the application of the fundamental right to the member of armed forces, police forces, or intelligence organization, so as to ensure proper discharge of their duties and maintenance of discipline amongst them. So Parliament has the power to modify the fundamental right. Yes, see, intelligence organization and all can't tell that I have a fundamental right to speech and expression. There are certain things, there are sensitive things that should not be come in the public forum. Okay, related to that, Parliament can make law that Parliament can make the law that this organization or security agencies, they can't tell everything in the public forum. Okay, so yes, that kind of modification can be done, and this power is given to the Parliament. Okay, this is the actual limitation. If there is a question asked in the exam that what are the limitations on the enforcement of the fundamental right, yes, there is a limitation. The limitation is that the Parliament can modify the power of the application if it is related to the fundamental right, if it is related to the armed forces, police forces, or intelligence organization. Okay, further, one more limitation. Another limitation is that when martial law, we have discussed this thing, I am just reiterating again. When martial law is in force, Parliament may indemnify any person in the service of union, territory, or state for any act done by him. That is by the Article 34. And whatever we have said, this Article 33. This is by Article 33, Parliament 1, that Parliament has the power to modify the application of the fundamental right to the members of the armed forces, police forces, or intelligence organizations, so as to ensure proper discharge of their duties and maintenance of the discipline amongst them. That is given by the Article 33. Yes, regarding that Article 33, that where the power of Parliament to modify the rights, in that whatever the members that I have said, armed forces, members of forces charged with the maintenance of laws and order, intelligence and counter-intelligence, or the person working in the telecommunication system offices of the mentioned officers, they do not enjoy much of the rights. They do not enjoy much rights. Only the Parliament has the power to restrict the fundamental right to these offices. Understand? And this thing can be restricted. This thing can be restricted only by the Parliament, not by the state. Okay? And they can impose, Parliament can impose the restriction regarding that thing. Okay? So this was all about this lecture. I hope you have understood all the aspects. Thank you. And now martial law force, that I have already told you in the fundamental right question in the lecture number 28.15, I guess. Okay. So when the martial law is in force, Parliament then Parliament can remove everyone's fundamental right. Okay, if the martial law is there. Until now, this has not been ever happened in India, this martial law thing. In the martial law, military take over the government position and all. This has never happened in India yet. Okay, but yes, there is a law regarding that. This comes under the Article 34. Okay, there are certain fundamental rights that is guaranteed by the Constitution may remain suspended while a proclamation of emergency is made by the President under the Article 352. Okay, as per the Article 352, if President declares emergency, then in certain cases, in some or not all fundamental rights, some fundamental right can be removed. Not removed, that can be suspended for that period. Understood? So what are the limitations on the fundamental right? One limitation is that Parliament can amend any power application related to the armed forces, police forces, intelligence organization. Parliament has the power to do that because for the security of the nations and all, they can do so. That is guaranteed through the Article 33. And as per the Article 34, there is again limitation. Limitation is that if there is a martial law is in force within the country or within any region, So the fundamental right of the people can be suspended as per the as per the parliament decision. Okay, parliament can decision. This is guaranteed. This is considered. This limitation is given by the Article 34, and yet this has not been ever applied. Martial law is where military will take over the country and they will start the rule. Okay, and certain fundamental rights are granted by the constitution may remain suspended, that can be suspended once while a proclamation of emergency is made by the president, and this power is given to the president through the Article 352. Okay, this was all about the fundamental right. Okay, we'll quickly see this right to information. Right to information, what is that? We'll see. Right to information has been guaranteed to every citizen. It has been guaranteed. Sorry, it has been granted to every citizen of India through which under which act? RTI, Right to Information Act. Okay, Right to Information Act of 2005. It has been guaranteed to the granted to the citizen that I have a right to information, which came into force. This right to information came into force from 12th October 2005. It is not a fundamental right. This remember, very important. This is not a fundamental right, but it entails a clause for the penalty in case of delay in giving the information to the applicant. Okay, an information commission has been set up at a central and state level to oversee implementation of the act. Understood? So whenever someone asks, is the right to information is a fundamental right? No, right to information is not a fundamental right. It is granted to every citizen through the Right to Information Act, which was passed in the year 2005, and there can be a delay in giving the information. For that, there are commissions which has been set up in a at a central level and a state level both. Okay, and yes, this right to information is not a fundamental right. Okay, this was all about in this lecture 29 section. Okay, we have discussed it 29.1, 2, 3, and I guess this is the 4th one. Okay, so this was all about in this lecture. Please like and subscribe. This is a new channel. Even though if you have any doubt, please put a comment over the video. I will be happy to help you over that. Okay, thank you.